Thank you very much. Yes, my name is Mark Malikian. I am a partner at Rains, Feldman, Luttrell in Chicago. And thank you for joining us for negotiating and drafting cash collateral and debt financing orders. This webinar is part 3 of the Financial Poise webinar series called Advanced Bankruptcy Transactions. I'd like to introduce my panelists. First, Matt Christensen, who is a managing member of the firm of Johnson May, based in Boise, Idaho. Matt has a general civil litigation practice and transactional practice, covers the commercial spectrum, including commercial bankruptcy matters. Next is Bob Richards. Bob is a partner at Denton's US. He's based in Chicago. Bob is, this may not be accurate anymore. I'm not going to read it. Bob works in large restructurings and distressed transactions in and outside of Chapter 11. Finally, we have Jeff Toole, who is a partner at Bernstein Buckley in Cleveland, Ohio. Jeff focuses on commercial debt restructuring and insolvency matters in restructuring, retail, real estate, healthcare, hospitality, and transportation. Jeff has also taught bankruptcy law at Cleveland Marshall College of Law. Our longer biographies are in the PowerPoint. Regarding the PowerPoint, we are going to work through the PowerPoint from time to time, sometimes perhaps going back and forth, but this is not going to be us just reading through the PowerPoint step by step. The PowerPoint is there for additional guidance and you reference. We are instead going to simply have a dialogue about cash collateral and debt financing and related matters. Finally, this webinar is a production of Financial Poise. To sign up for the Financial Poise free weekly newsletter, go to www.financialpoise.com. And with that, I would like to start the webinar. We decided that from time to time we would actually take up roles depending on what we're talking about, with Jeff taking the role of the lender, Matt taking the role of the debtor, Bob taking the role of the creditors committee, and periodically other junior lenders in the case. And I'm not sure what my role is. We'll have to see. With that, let's get started. First, let's just talk about what cash collateral is. Jeff, I'm going to throw this first set of questions to you. What exactly is cash collateral? Can you give us some examples?
Sure. Cash collateral is defined in Section 363A of the Code, and it's basically cash and cash equivalents in which the estate has an interest and in which some other entity has an interest, and that interest typically is a result of a security agreement or a mortgage or a pledge agreement or something of that ilk. In other words, they have a security interest or a mortgage lien of some kind, typically in the cash. The cash can take many different types of forms, hence cash equivalents. It can be deposit accounts, it can be securities, it can be negotiable instruments. It also can be cash proceeds resulting from the disposition or collection of other types of collateral. So, for example, collections of accounts receivable are cash collateral. Proceeds realized for the sale of inventory also would be cash collateral. But it's not limited just to personal property. It also covers real property. So rents and income derived from income-producing real property, like office buildings, apartment complexes and such, also would be cash collateral. And the definition is expansive enough to include specifically the accounts and fees and charges that are derived from motels and hotels. So all of those things are cash collateral, potentially, again, assuming that some other entity has an interest in it under a security agreement or something of that ilk, whether the cash arose before bankruptcy or during the bankruptcy.
All right, thank you. Bob, before we go on, do you have anything to add?
Just that, the reason that cash collateral has special protection is because cash can disappear very quickly. And as we'll discuss, the court is very concerned about making sure that anyone who has a right in the cash rights are preserved in one way or another.
Right. So Bob, I'll continue with you. In effect, cash collateral is at its core, the debtor's operating cash, but also includes all these other categories of potential or realizable cash. Why can't the debtor just use its cash collateral during the case as it did before it filed bankruptcy?
Again, there's a specific concern about, use of cash and dissipation of cash. So there's really two ways under 363 that you can use cash. One is by agreement with the lender. So I would reach out to Jeffrey and negotiate what's called an agreed cash collateral order. And not only would it say I could use my cash, but typically Jeffrey would have some quid pro quos he wants for the use of the cash that we'll discuss later. Or if we can't agree, then I would go to court if I were the debtor's counsel and get an agreement, an order of the court saying I can use the cash and that the lender's interest in the cash is adequately protected. If I don't do that, and I did have one case where I was the lender where someone didn't do that, there are severe consequences because it's a big no-no. And in fact, that case ended up getting dismissed when the factory owner just kind of used cash and didn't ask the court for permission or ask my lender client for permission.
Jeff, from the lender's perspective, what are your concerns with respect to use of cash collateral and agreements to use? What do you focus on?
Well, obviously, in terms of the quid pro quos, I'm looking for all manner of protections with respect to the cash and my position generally, because as Bob correctly pointed out, cash can dissipate quite quickly. I don't want to get into the details of what those provisions would be because we're going to be talking about that later. But amplifying on his comment about what might happen if somebody uses cash collateral without court permission, I mean, there are all sorts of bad consequences. Dismissal is one, which he mentioned. Because unauthorized use of cash that causes substantial damage to at least one creditor, which would be, me, the lender, is a basis for potential dismissal of the case or conversion of the case to Chapter 7 liquidation or the appointment of a trustee or an examiner, depending upon what the court decides is in the best interest of the estate. Alternatively, the affected creditor could seek relief in the automatic stay for cause. And essentially take its property away and leave the debtor potentially without the means to operate. And beyond that, there's also an independent basis for claiming that it's gross mismanagement that justifies the appointment of a trustee under a different code section, section 1104. So needless to say, from my standpoint, I want to make sure the cash is accounted for. I want to make sure it's segregated under section 363C. I want to make sure it's not spent improperly. And that ultimately leads to hopefully the dialogue, the negotiation that we're going to be talking about in more detail in a few minutes.
Right. So Matt, let's say you're debtor's counsel and you unfortunately learned that debtor's owner has perhaps been using cash either without a cash collateral order or more like outside the provisions of the cash collateral order. What would you do? What would be your first step? Let's say the lender hadn't discovered it.
First thing I think I would do is make sure that whatever he was using was actually cash collateral. So there may be cash that the debtor has or that it receives that really isn't collateral of somebody else. It's rare, but it happens once in a while. So if it really is something that is subject to a lien that some lender actually has, if the lender hasn't found out about it, so the first thing I do is tell the guy to stop. You can't continue to use it. That's just going to compound the problem. And then probably file a cash collateral motion requesting like a nunc-pro-tunc approval or something. Especially if like they continued making the payments to the lender, so there wasn't really a huge damage to the lender that they wouldn't have already gotten if there was a cash collateral order entered earlier in the case, right? If there was some sort of adequate protection payments to them or other protection or something along those lines. just try and get non-pro-tunc approval of the new motion that I'm filing. But definitely tell them to stop.
Yeah, I've been involved in 2 cases and where that happened, and one of them got dismissed out of hand. The other one, the debtor was able to cure eventually by negotiating with the lender. All right, let's move on to the next question. Matt, I'm going to stay with you. What happens if what happens if cash collateral just isn't enough? You don't have enough cash. What do you do next?
There's a couple different options. I mean, if there's assets that the debtor has that aren't secured to somebody that can be liquidated, they're either non-performing or unnecessary assets, sell those, get cash that way. I think the probably more common option, and I throw that out as an option because I did have a case where it was a fairly large ski resort case, and they discovered just prior to filing that none of the titled vehicles had been perfected. Any liens on those hadn't been perfected, so essentially they were free and clear vehicles. And so they funded the Chapter 11 case by taking all the vehicles that they didn't need and quickly selling them, and then pulling that cash in and using it. So that is an option every once in a while. I think it's probably pretty rare. More commonly, you're going to use a combination of a cash collateral and some potential post-petition financing through a debtor-in-possession loan that you're going to get after the case. And depending on the time frame, it's either immediately when the case is filed if you need those funds just to continue to operate, or maybe you can use and operate on cash collateral for a bit, but eventually you're going to need some DIP funds either to help with the plan or to just help with your operational expenses, including all the professional fees that you're going to also be incurring until you get to confirmation.
All right. So Bob, let's say you're representing the creditors committee. It's early in the case, and one of your first concerns, of course, is whether the debtor can actually cash flow from week to week. You have any further thoughts about, looking at, like, in terms of the committee's goal? What's the committee's goal at this point? Say it's early in the case. Looking at cash flow, you don't necessarily have DIP financing motion up. We'll talk about DIP financing later in this webinar. What are your immediate concerns?
Well, my immediate concern is, can the business operate in a way that ultimately, hopefully there's some value for me. Some of my committee members may be trading partners and they want to make sure they're going to get paid for what they're doing going forward for the business. So, those would be some of my concerns. It may be that, the debtor is able to live on a skinny down budget, less than it'd normally spend, and live off cash for a while. And the other thing is, if they can live off cash for a while, I want to make sure that whatever DIP financing gets approved is the most favorable. And sometimes the DIP financing offered by the incumbent lender has more baggage and more conditions than I might like. For instance, the existing lenders may say, I'm only going to fund for 60 days, and you got to sell everything on a fire sale for 60 days. My constituents are likely to get wiped out if that kind of DIP gets approved.
Jeff, we're going to move the next question on to you. So let's talk a little bit more. Bob mentioned the word budget. Budget is important in bankruptcy cases. So let's talk about the common tool used in bankruptcy cases, the 13-week cash flow. Can you, Jeff, talk about the 13-week cash flow and a little bit about how it might differ from the way a company typically keeps its books, and give a little bit of also your perspective on 13-week cash flow from the lender's perspective in particular?
Well, from the lender's perspective, the 13-week cash flow, 3 months basically, is key because it gives the lender both transparency to know, what's going to be expended, what's going to be received, how its cash collateral is going to be used. So it has that understanding going in, and so it's easier to police that behavior and monitor the debtor to see how well the debtor is behaving, whether it's using cash appropriately, and ultimately whether it's making money or not making money, as the case may be. So, the budget is the guidepost, or at least a guidepost, governing how the debtor conducts his business going forward. So it's an opportunity for the lender to really have some sway over how things are going to progress without necessarily invoking the horrible C word for control, which is a different issue. The 13-week budget, resembles what you would expect in terms of the basic budget, but with some bankruptcy, variations. The basic stuff, of course, is to identify the receipts from whatever the sources may be, and all the expenses that the debtor anticipates paying. And all this should be done on a cash basis, not an accrual basis. From a lender standpoint, the lender wants to know what cash is coming in the door during a given week and wants to know what cash is going out the door for a given week. Expenses that get accrued that aren't going to be paid for some period of time are confusing, not helpful. But obviously, it's important that all those expenses be listed completely, fully, because that's going to be the limitation, if you will, on what the debtor can pay out. So it's got to cover everything from payroll, insurance, taxes, other operating expenses, repairs, maintenance, things of that nature. All of that needs to be laid out. The primary difference between this kind of budget and a bankruptcy budget is there are going to be additional bankruptcy related expenses that have to be reflected in that budget. And they would include things such as professional fees for the estate professionals, the debtors counsel, the unsecured creditors committee counsel, if one's been appointed yet. Other professionals who are working for the estate, like accountants and things of that nature. There may be, special counsel, other law firms that aren't working on the bankruptcy per se, but are handling discrete non-bankruptcy legal matters that have to be addressed. So they're sometimes called ordinary course counsel, but whatever the moniker, they're dealing with things like labor and employment issues and environmental issues and stuff that's not necessarily endemic to the bankruptcy, but nonetheless has to be budgeted for because that work needs to be done. So they have to be taken care of in that sense. U.S. trustee quarterly fees also have to be budgeted. That's unusual because it's specific to bankruptcy. Every quarter, the debtor has to pay a quarterly fee based on disbursements made during the preceding quarter. And so that amount needs to be reflected. Now, that's at least for your standard Chapter 11 case. In the Subchapter 5 context, which are basically small business Chapter 11 cases, there is no U.S. trustee fee that has to be accounted for because they're not charged. But there's something else that has to be accounted for in the budget, and that would be the fees and expenses of the Subchapter 5 trustee, who is specific to Subchapter 5 cases. So those are among the things that have to be addressed. In addition, there are kind of bankruptcy unique expenses that are going to pop up beyond those in the nature of claims. So, for example, if there's been a shutdown or a layoffs of different plants, there might be warrant exposure, Workers Adjustment Retraining Act or a Notification Act. Any claims arising from that probably should be accounted for. There may be reclamation amounts that have to be provided for as well under Section 546 of the Code. There might be potentially some 503b9 claims for goods delivered within the last 20 days preceding the bankruptcy, listed the value of those goods that also have to be taken into account because they're administrative expenses. And the question becomes, when will those be paid? But they need to be in the budget at some point. So, those types of examples give you an idea of what the budget ought to contain. The bottom line is you're going to have in there, what the net outcome of cash is, including after taking into account any draws on any debtor-in-possession financing, which again we'll be talking about, so that essentially on a weekly by weekly basis, the lender and everybody else can see whether the debtor is cash positive or cash negative, and also examine the trends. How will this debtor fare over the next 3 months? Is the cash being accumulated over time? Are they basically living hand to mouth? Are they losing money? All that, is reflected in the budget, as well as demonstrations of what their cash needs may be and how much money they need to borrow along the way.
Thank you, Jeff. Matt, as debtors counsel, in your experience, do you typically have the debtor prepare the 13-week cash flow or start with a 13-week cash flow, or do you hire a professional?
It depends on the size of the case. If it's a Subchapter 5 case, I'm usually just having the debtor do it because that's a small business. There's lower number of debts. They're usually more tuned into what their budget is. If it's a larger Chapter 11, again, It depends on the sophistication of the debtor themselves. If it's a small mom and pop business, I usually would have them do it themselves. If it's a larger enterprise, multi-million dollars in assets, multi-million in income each month, then usually I'd have a outside professional, whether it's a financial advisor, whether it's just an accountant that they've worked with, but someone else come in to do it. I think in those bigger cases, you've got a creditors committee, you've got more active secured creditors. They are probably going to trust the third party professional doing it more than they do the debtor's ownership or employees doing it. And so you just get a little bit of that trust built up by having an independent third party work on it.
Thanks. Bob, is that true? Would you trust the independent third party?
As a committee, often I tend to be a little more confident in them. Sometimes debtors are debtors for a reason, and one of those reasons may be their accounting and controls aren't so strong. So, I would generally have more confidence in that. And from a committee perspective, I definitely want to make sure there's room in the budget to pay the committee professionals.
Of course. All right. Well, let's talk about that. We've worked through the budget, and we have now determined that this debtor, unfortunately, isn't going to be able to survive on its cash in and out during the case. It's going to need help. So it's going to need to borrow money. And we call that debtor-in-possession financing in the bankruptcy world, or DIP financing. So let's talk about that. Bob, I'm going to stay with you. You explain with more particularity exactly what DIP financing is and some of the elements of it, what the bankruptcy code requires.
Sure. So DIP financing refers to debtor-in-possession financing, which is the kind of financing you do in a Chapter 11. You can have financing in other chapters, like, could have financing in Chapter 7, but DIP financing generally refers to financing in a Chapter 11. And there's different kinds of levels of financing you can have. You could just have unsecured, debt, for instance, a trade creditor continuing to supply goods, or an unsecured loan. Usually there's enough encumbrances in a bankruptcy case that it's hard to find credit on that basis. Sometimes then you can find a secured loan on a junior basis, or at least ahead of some of the administrative cases in 11. And then the one that you sometimes see, especially from outside lenders, would be 364D, where you're actually trying to prime an existing lien, and there's certain standards you need to meet to do that. One of the hats we had talked about me wearing was the junior lender. And certainly in a bankruptcy case, if I'm permitted to under my intercreditor agreement, I may well consider providing a rival DIP financing facility, because my facility may be less expensive and more favorable than the one that Jeff and his senior lender client is going to propose.
Oh, Mark, I think you're muted.
I am. Sorry about that. So Bob, if you are a junior lender and you do lend on a priming basis, you then prime the senior lender, at least to the extent of the lending. Jeff, how do you feel about, as a lender, how do you feel about being primed?
I tell you, there's no quicker way to get into a major dispute early in the case than to try to prime your existing lender, unless for some reason your existing lender is on board with it, which I can't recall a case in which I've seen that, frankly, but I suppose it theoretically could happen. It creates some issues for the secured lender, the existing secured lender, in the sense that, if the priming occurs, they're not going to have somebody in front of them that is, potentially better able to drive the case, and obviously is expected to be paid first. Their position could potentially erode my position, which doesn't make me very happy. And needless to say, it's another mouth at the table that has to be fed under a Chapter 11 plan. From the existing lender's standpoint, it creates both risks and opportunities. The risks I've already described. Opportunities, maybe this is a situation where I, as the lender, want to step up and say, you know what, don't worry about priming me out. Here's what I'm going to do. And it could end up, with the existing lender extending credit they otherwise were not really inclined to do, so that they don't get primed, perhaps on better terms than were initially anticipated. So to some degree, talking against my own best interest, to some degree, finding an alternative lender who's willing to step in and potentially prime might be a way to motivate the existing lender to be more reasonable, more cooperative, from the debtor's point of view. From my point of view, needless to say, it's going to be an aggravation and could end up costing a lot of money and time and effort and potential risk for the debtors in fighting about it early in the case.
Would the size of the junior priming loan, would that make a difference? Let's say you're in for 50 million and somebody steps up to loan 2 as opposed to 25 million.
Obviously, that's going to play into it. If it doesn't appear to be a substantial risk to allow that level of, or that tranche of additional debt to come in, maybe I'm okay with it. Part of it depends on whether I perceive myself to be, oversecured, meaning, my collateral is worth more than my debt, and if so, by how much? Is my cushion enough that this extra $2 million is really not going to impinge on me at any time in the foreseeable near future? I have options in case something happens. Or am I essentially close to being underwater, and this $2 million can end up pushing me further underwater? Those are among the issues I'd have to look at to figure out whether it makes sense to say yes or no.
All right, thanks, Matt. We're gonna turn to you. Want to talk a little bit about the concept of adequate protection. Can you explain what adequate protection is and how it figures into this fight with the lender and sometimes with the junior lenders?
Sure. So going back to basics, I guess. If you've got a secured lender, and I'm owed 50 million and I've got a security interest on a bunch of the assets of the borrower, I'm entitled to protection from my position changing. Right. So if I'm owed 50 million and I have collateral worth exactly 50 million, which never actually happens, but let's assume that it did, then I'm entitled to not lose the value of the collateral or not increase the amount that I'm owed. What I'm entitled to is my position at least remaining the same, if not getting better. But it's not supposed to get worse. That's what we're trying to protect from. So in the context of a DIP loan or a priming lien, the value of the collateral that secures me matters, because all of a sudden I'm going to be now junior on that collateral to whoever the DIP lender is, and maybe that additional debt is going to decollateralize me somehow. So all of a sudden now I'm not fully secured. That's going to be a big issue. And so the value of that collateral becomes part of the fight. I may, as a existing lender, I want the value to be lower so that I have better arguments why there shouldn't be priming liens. As the debtor, I want the value to be high, because then there's an adequate cushion and you're going to still be protected even if this other guy comes in front of you. So I'm entitled to that protection, whatever form it comes in. And there's different forms that adequate protection can come in. I think we'll cover that in just a little bit. But I'm entitled to not have my position harmed, no matter what my position is.
Thanks, Matt. Bob, I'll throw this to you. You don't have to wear a committee hat for this, just a bankruptcy counsel hat. So in Matt's example, you had say the $50 million worth of collateral and $50 million of debt on the filing day. And so you start from that basis, and it's accruing interest going forward. So the standard, given the standard diminution in in value, or diminution in I guess position is the word we use. Trying to think of how to phrase this. How would you assess that in terms of what would be your ask in terms of adequate protection? Just thinking off the top of your head, you got $50 million in debt, you've got $50 million of collateral allegedly, and every day that goes by, the clock is ticking in. Let's say the value isn't necessarily going up or down. What would you ask for?
Well, yeah, if I'm the senior lender, I'm probably saying the collateral's worth 55, not 50, and that therefore I'm oversecured, entitled to interest and entitled to my attorney's fees. If it's strictly 50-50 and I'm not oversecured, I might not be entitled to fees. And then, there's a lot of what ifs on how the company's going to do in bankruptcy and what's going to happen to the collateral values. So I'm going to want replacement liens. For instance, if they're selling my inventory, I want a lien in the new inventories. If they're collecting receivables, I want liens on the new receivables they're generating. And then if there is anything unencumbered or that has excess value, I'd like a kind of a backup lien on that. So if it turns out that during the case, my collateral went down from 50 million to 40 million, then there's something, that gives me a lien to help make up some of that loss. And of course, I won't know until after the fact kind of what happened to my collateral values during the case.
Right. Jeff, I'm going to move on to you because we touched on, we're going to go back to the concept of adequate protection itself. We'll get back to some of the things Bob talked about in a bit. So you're the lender, you want adequate protection sort of on an ongoing basis for now. What are you asking for? Interest, for example, or you get what else are you asking for?
Well, if I'm oversecured, $55 million worth of collateral and 50 million in debt, yeah, I'd like to be paid interest going forward at whatever my standard rate is. There's a big division in the case law as to whether you can also get paid default interest. Some courts say yes, some courts say no, but the point is I want to get paid some interest. I also want, obviously, to get my fees paid as well for my lawyers and others who are looking out for my interests to make sure I'm not going further in the hole for that. So, those types of quote unquote periodic payments would be among the requests I'd make. And in the screen we had up a moment ago, we just, describing the types of adequate protection or how it can be provided. Periodic payments is, first on the list for a good reason because it's the one that is most often requested, at least to the extent of diminution in value. When you're oversecured, though, asking for interest, asking for fees doesn't necessarily require diminution because you're entitled to that under 506B. So you got to distinguish between whether you're oversecured asking for interest based on 506B or whether you're close to the cusp or underwater, asking for compensation for actual loss in value of your collateral. But either way, you want money, you want payments. Bob already mentioned the notion of replacement liens. That's critical in this context because Section 552A of the code provides that to the extent my lender, has a security interest or liens on property coming into the bankruptcy, those liens are cut off on most categories of property. So accounts receivable, inventory, equipment, things of that nature that are acquired or come into existence after the bankruptcy will no longer be subject to my pre-existing pre-bankruptcy lien, with a limited exception, unless I get replacement liens to essentially cover myself for those things that are acquired post-petition and expended. So as a receivable that existed pre-bankruptcy is collected, and replaced with a new receivable, I want to have a lien on that new receivable. I want to have a lien on new inventory that's acquired to replace the inventory that's been sold that I had before. So replacement liens are pivotal, again, at least to the extent my value otherwise would go down. Another category, which is listed on the screens, is the so-called indubitable equivalent, some other relief that gives the creditor essentially what they otherwise would have gotten, so to speak. The code doesn't define that. Most of the case law talks about what isn't indubitable equivalence. The one thing the code does say is that simply handing somebody, a lender, an administrative expense claim, which is basically an unsecured claim that has a higher priority than pre-bankruptcy claims, isn't indubitable equivalence. So that we know that doesn't work. But other things might, for example, if there's unencumbered property out there, giving a lien on that unencumbered property to backstop the secured lender might be indubitably equivalent, provided that the property you're giving the lien on is, relatively liquid or is capable of being monetized, relatively easily. If you're oversecured, meaning your collateral is worth more than your debt, then the equity cushion, which is the last item on this list, becomes an important consideration. Depending upon the size of that equity cushion, that might be enough to, in most courts' eyes, deem a secured lender to be adequately protected without requiring them to get payments, although they should still get replacement liens for the reasons I've described. Generally, under the case law, an equity cushion of 20% or more is considered by most courts to be adequate. An equity cushion of 11% or less typically is not. And in between 11% and 20%, the courts are divided. It really just depends on the facts and circumstances. But those are among the classic ways that debtors in the states can provide adequate protection to creditors, depending upon whether they're oversecured, right on the cusp, or underwater.
Thanks, Matt. I'm going to lob a quick question to you. Not wearing your debtor hat necessarily, just your bankruptcy restructuring hat. Equity cushion. In the instance we're talking about, let's say we're talking here where we've got not just a secured lender, debtor has its collateral, needs to be protected, it's entitled to protection under the statute, but it's also the DIP lender. So it is lending money into the case. So its collective debt is increasing. Does that diminish the equity cushion?
That's a good question. I would say yes. Not in the same way that if the two lenders were different lenders, but that existing lender is most likely treating the DIP loan essentially as a new loan. It's not just adding balance to the old loan, but in any case, the outstanding debt is increasing, and so the equity and the value of the equity isn't changing. So the cushion itself is getting smaller. So I think it would be.
Right. I'm going to throw one to Bob, and you can wear your committee hat for this. Same situation. You've got pre-petition lender is also your DIP lender. It's not a roll up. So the post-petition loan is a new loan. It's not being crammed together with the pre-petition loan. And the lender is lending into the case. At the same time, the debtor is making adequate protection payments back to the lender. If those were, how do you feel about that concept? The lender basically lending money into the case to pay itself adequate protection payments. What would be your position as a committee?
Well, I mean, I focus more on things that make the business operate, and the lender paying itself doesn't. Sometimes you have to do something along those lines just to have peace with your lender. You need someone financing the case, but I'm going to resist that if I can. I'm certainly going to fight default interest rather than regular interest. The DIP might include large fees, large unused line fees. So, there's any number of things that could really grow the size of the secured debt ahead of me and ahead of my client's prospects for recovery. So anything I can do to block those, or at least to minimize them, I'm going to strongly think about taking those positions and objecting.
Thanks. Yeah, I don't realize that's an unusual situation maybe, but I just faced it in a case and I was curious about people's thoughts. The solution in the case we were in was the lender was entitled to adequate protection payments, but they were effectively accruals. They were PIK to come out of future sales. So it wasn't actually day-to-day cash coming out of the debtor's account. An interesting kind of compromise. All right, let's move on. Let's talk a little bit about the creation. You've agreed to finance. So you've got a debtor, you've got a lender, you've agreed to actually take financing. What happens next? You've got to create an agreement. Matt, let's talk a little bit about that. You're negotiating an agreement with the lender for a debt financing. You talk a little bit about the issues that come up there.
I want to take one step backwards though, and ask a hypothetical to Jeff on the equity cushion still. And this is totally out of the blue, so he hasn't had any time to prepare. Let's say you've got more than one pre-existing lender. So you've got a first position lender and then a second bank as a second position lender. And there's an intercreditor agreement between those two that one of the terms in there is the second position lender can't actually access that collateral unless the first position lender forecloses first or is fully paid. Does that second lender have an equity cushion? Assuming that with the total amount of both loans are still equity above that, do they have a real equity cushion?
I guess it depends on which lender I represent. If I'm the first lender, you know, the senior lender, my answer would be, oh, of course they do. There you go. Hey, come on. I'm not sure the subordinate lender necessarily would agree that their position is well protected as they might otherwise, you know, appear. Generally speaking, you know, in my experience, these intercreditor agreements go on ad nauseum about what will happen at a bankruptcy and who can do what to whom and who has to stand in line and wait. And the provision you mentioned about having to wait for the first lender to get paid in full is what I typically am used to seeing as well. So in the end, you know, the second lender may not have a whole lot of room to complain because after all, they did agree to those terms and the court is likely going to enforce those terms, even if they, you know, are pitching a fit about it. But it might, to some degree, provide leverage for the lenders collectively to approach the debtor and demand more in order to ensure that their positions are not eroded one against the next. But I think that would depend on the facts of the case.
Okay. So now we can take a step forward, I guess, and I'll answer Mark's question. Sorry. So from the debtor's perspective, you're negotiating the terms of the DIP agreement. I want to have as much freedom as I can. You give me that money, I'm going to use it as I see fit. Of course, the lender wants to make sure it's used in a fashion that well, on the creditors committee, that it promotes the business, it keeps the business going, keeps the bankruptcy case moving forward. We're not just gonna wallow down in the mud too much. So from a debtor's perspective, you know, I may put together a DIP budget that says, look, this is what I'm projecting I'm going to use these funds for. That's going to be tied in with my cash collateral budget probably to show, you know, what the interplay between my operating cash is and the DIP financing. The lenders are going to want some kind of reporting on, you know, okay, that's what your budget is, but, you know, are you actually sticking to it? So whether that's some kind of variance report, whether it's a borrowing based certificate, whether it's some sort of ongoing reporting, from the debtor's perspective, I want the reporting to end there, right? I provided your reports, I've done my part. Creditors, I think, are going to want some control, not necessarily control over the spending, but if you go too far outside this budget, that either terminates the cash collateral authority or gives us ground to go back to the court and say, hey, they're way out of line. And so some lenders are going to want, you know, any expense over X amount to be approved by the lender. If I'm the debtor, I'm pushing back on that as hard as I can. Look, as long as they stay in my budget, you keep your hands off me. So reporting is always going to be an issue, and what reports and how often. How often, you know, there's monthly operating reports that the debtors have to file already. And so from a debtor's perspective, I don't want to have a whole lot of extra reporting that's over and above what I already have to do. And so if it's monthly reporting, I want it to be something I can just tack on to the regular monthly report that I have to file for the UST anyway. But most creditors don't like monthly reporting, especially when it's 3 weeks after the month has already ended. By then it's too late to really notice any emerging trends. So you're probably gonna end up with something weekly, in which case I want it to be the easiest report possible for me to put together, because that's just taking time away from operating the company.
Thank you. Let's talk a little bit about cross collateralization. And, for this, I'll move on to Jeff. Jeff, cross collateralization, would you explain what it is? And then, how it factors into depths and the negotiation over them.
Cross collateralization basically is a short form for a lender during the course of the bankruptcy case, typically a pre-petition lender who's also going to be the DIP lender, loaning basically for the purpose of causing its pre-bankruptcy claim to be secured by post-bankruptcy assets. And a roll-up is the classic way to do this, or it's one of the classic ways to do this, which is basically that the debtor takes out a new loan, which is sufficient to pay the existing loan, the pre-bankruptcy loan, as well as whatever additional amounts it needs to operate in the course of the bankruptcy, new lending. But then the totality of that new loan, which includes the pre-bankruptcy balance, is now secured not just by the pre-bankruptcy assets, but also by the post-bankruptcy assets. So that in a sense bootstraps the pre-bankruptcy lender into a post-bankruptcy better position, at least from other creditors' point of view, than would be the case if they didn't do that kind of roll-up or cross-collateralization.
Bob, as counsel of the committee, how do you feel about cross collateralization and roll-ups?
Well, I mean, especially if it's a roll up where they're rolling up the entire debt immediately and not just kind of as receivables come in. I'm typically going to oppose it. One really significant is I may be very interested in a Chapter 11 plan of reorganization and, getting payments over time or getting some equity in the reorganized entity. If the entire secured loan gets rolled up into a DIP, then my only choice on emergence is to cash out the DIP loan rather than stretch out the DIP loan under some sort of cram down. So I really don't want to see any roll up, but certainly a complete roll up, and anything that they're encumbering likely is something that otherwise could provide value to my clients. So I'm going to resist it on that basis as well.
Let's move on and talk about some other elements of DIP. Bob, I'm going to stay with you. Why don't you start with explain what timelines and milestones are.
So could you repeat what the question was?
Could you, why don't you talk about timelines, milestones, and some of the other elements?
So
DIP agreement.
It's very common in a DIP agreement, especially from an existing secured lender, for them to have very strict and tight timelines. Like you have to have bid procedures within 30 days. You have to have an auction within 75 days. You have to, close the sale within 90 days. And generally, the quicker the process is, especially if they haven't marketed the assets before, the more likely there is that there's not going to be excess value to my creditors. And also, from a creditors committee perspective, I would like the alternative to be able to propose a plan rather than be stuck only with a Section 363 sale of assets. Again, some DIPs would permit that alternative tracks, others would only permit effectively a sale. But from a committee's perspective, I want some time to get that out. Another thing, frankly, if the existing lender is being too difficult, is I don't want the existing fees to be too burdensome, because I want time to find an alternative DIP. Let's say I have a buyer who needs a little more time, but ultimately may be more willing to work with the company. I'd like the ability to take out the senior lender's DIP with the strategic lender's DIP down the road. You're on mute, Mark.
Sorry, there's some noise outside, so I'm trying to stay muted. Let's talk about some of the other elements. Jeff, you want to talk about carve outs and burial expenses? Explain what those are.
Sure. I mentioned earlier on, talking about budgets, that there needs to be some provision made for payment of estate professionals. That also comes into play in other aspects of the cash collateral or DIP financing order with respect to the replacement liens or any new liens that the lender or lender is going to be acquiring under 363 or Section 364. Without some form of carve out, which I'll describe more fully in a second, without some form of carve out, the estate professionals run the risk of working for free or having to wait a long time to get paid, because otherwise they're just administrative expense creditors, like the guy who sells paper clips and whatnot to the debtor, and they get paid once the collateral securing the loans has been paid out to the secured lenders. The purpose of a carve out is to provide the means by which those professionals can be paid as the case progresses, rather than having to wait for the end of the case to arrive to see where the dust settles. The carve out, as the name suggests, is an agreement by the lender or the DIP financier, as the case may be, to set aside a certain portion of its quote unquote collateral, typically cash receipts, collections of receivables and such, with which to create a fund for the payment of estate professional fees as those fees come into existence and as they are either approved in some appropriate process or allowed by the court, or both, as the case may be. So, for example, if the debtors council anticipates that over the course of the first 13 weeks of the case, they're going to amass a $50,000 bill, consisting of however much each week, they need to have a carve out, at least for those 13 weeks, of $50,000. Money set aside on which they have first dibs and on which the lender is essentially agreeing to stand back and let them be paid. And so for all the other professionals, committee professionals and others who are waiting to be paid for the work and the services they're rendering. The reason the carve out is important from a systemic point of view, from a bankruptcy point of view, is not just so the professionals get paid. Professionals like to be paid for their work, but because, as everyone recognizes, in order for a case to progress, in order for the reorganization to proceed, the debtors, the committee have to have appropriate professional representation to get the work done, to move the case through the process. And without a carve out, it's very difficult to attract professionals and keep professionals to get that work done, which is essential for reorganization to hopefully succeed. If the case goes sideways, though, and ultimately ends up going into Chapter 7 liquidation, which sometimes happens, then what happens to the expenses that are incurred to basically bury the debtor, to cease its operations, to dispose of its assets, to sell at auction or otherwise, to pay a trustee if one comes in Chapter 7 to handle all that, to liquidate the assets, et cetera. That's where the burial expenses become important. And likewise, the trustee or whoever's handling that disposition of assets is going to need to have some capacity to pay those expenses, not just for its own work, but also for the work of auctioneers and appraisers and whoever else might be involved in that process. So a carve out for burial expenses also is something that the parties typically will negotiate at some point along the way to make sure that those expenses can be paid if the worst happens and the case tanks.
Thanks, Jeff. I'm going to go a little off our script, only in the interest of time. And I want to talk a little bit of, and Matt, I'm going to throw this to you briefly. From the debtor's perspective, one of the key elements is default and acceleration provisions in a DIP. As a debtor, what are you looking for, and what are you looking to limit in connection with default acceleration provisions?
I don't know that it's, well, I guess there's one comment I'd make, that it's common in the bankruptcy court, and one comment that is common just to any sort of loan. And as with any loan, default and acceleration of the loan, I want as much warning and as much time to cure that default as I can. So you've got to send me a written notice. I have time to fix the problem, whatever it is. And I want the default So in the bankruptcy context, generally default would trigger either stay relief or something along those lines. I want a couple of things. One, the default to trigger the lender going back to the bankruptcy court and seeking stay relief. Not that stay relief will be automatically granted. I think most judges are hesitant to say, yeah, it's automatically granted if there's a default. They want to provide the creditors committee and the UST and them to chime in. And I want the default that triggers stay relief to be a monetary default, not a non-monetary default. If it's a reporting issue that I just didn't get a report sent to them in time, I don't want that to trigger full recourse and full foreclosure on whatever assets they have. So I'm like I said, it's a lot of it is the same sort of protections I would ask for even outside of bankruptcy context, except for the stay relief portion.
Thank you. I am going to move forward to, why don't we talk, we could talk about lots of other provisions on debt financing agreement, but we are going to run out of time to do that. So, Bob, I'm going to throw this next section to you. Debt financing and cash collateral. Do you need court approval? And if so, how do you go about seeking it?
Yeah, you need court approval for both, and sometimes they're combined. For cash collateral, at a minimum, you need to notice anyone who's got an interest on the cash, and there's two standards for that. One is interim, so I need to make payroll this week right after I file. I need to buy some goods. How much money do you need for the next 14 days? And then a longer term final cash collateral order. And courts are very reluctant, even for a business that's struggling, to not give it any chance and to shut it down on day one. So you're almost always going to get some sort of interim approval. Likewise on debt financing, it's typically an interim motion seeking, I need this much additional financing for the next 21 days. And then ultimately, I want a facility for 9 months that goes up here. But in the initial hearing, again, often on a day or two notice, very quick, is, how much more money does the debtor need for these 14 days? And if I'm another party in that situation, once you get a DIP loan in place, there's often a lot of rights that are granted that can't necessarily be unwrung. So, even though you say, oh, it's only 14 days, it's only 21 days, some of that can really give whoever is providing the lending, a real leg up in the rest of the case.
Thank you. Jeff, throwing this to you, what's your perspective on interim and final financing from the lender's perspective?
Well, from the lender's perspective, I'd like to get typically to a final order as quickly as possible. I think, Bob was obviously right that, on an interim basis, the court's going to have to do something to keep the case going until you get to that final hearing, however long that may be. In many cases, that process gets dragged out. But the bottom line is that, I want to try to get the final order in play or in place rapidly. And ordinarily, I'm going to want, the order to contain, both the interim and the final order, to contain, all manner of protections for my interests. We talked about some of them already, but there are a whole vast quantity of others that could be included, including the so-called dive, which is where the debtor essentially stipulates in exchange for my cooperation in either allowing use of cash collateral or extending more credit. They stipulate to the validity and perfection priority of the claims that the lender has, to the amount of its indebtedness that's secured by those. Sometimes whether or not the lender is fully secured, that there are no claims, causes of action, et cetera, that exist, and potentially that any such claims are released, which is a controversial area at these junctures. But I want to have all those types of protections built in at the front end, at the interim order, and try to sustain them in the final order, because once the final order comes down, obviously, then it's final, subject to appeal, but otherwise it's binding on the rest of the world. And as many protections as I can include, I'm looking for.
With respect to the dive provisions, Bob, I'll go back to you for this one. You're wearing your committee hat. How do you feel about the debtor stipulating to the perfection of the lender's liens and the perfection of all of its actions pre-petition?
I mean, typically there's a carve out for that for not for the committee to challenge it. And so long as I've got adequate time to investigate, I'm happy to take on that challenge. Some things are, obvious, like they filed their UCC, they didn't, they took the vehicle titles, they didn't. Other things are more tricky, is there a lender liability type of action or something like that? But I want adequate time as a committee to investigate that. And part of the the negotiations I'm probably going to have with Jeff and his client is how much money can I spend investigating that? Because he may say, yeah, there's a carve out for committee fees, but in terms of investigating me, which I don't really want to incentivize you to do, I'm going to keep that as small as possible, because I don't want you to cause me a lot of grief and go looking in every nook and cranny of my loan file in my loan office.
All right, thanks, Bob. Well, we have once again hit the hour, and there are more things to talk about, but we have talked about enough for this webinar. I want to thank my panelists, Jeff Toole, Matt Christensen, Bob Richards. Thank you very much for a very entertaining discussion. And with that, we are going to conclude the webinar. Thank you very much to our audience. Everybody, take care.